Tantor Audio, a division of Recorded Books, presents Moving Past Marriage, Why We Should Ditch Marital Privilege and Relationship Status Discrimination and Embrace Non-Marital History, by Jaclyn Geller, Ph.D., narrated by Laural Merlington. Author's Note: people from chapters 5 and 6 whose stories circulate in the public domain are identified by their real names. To protect others, I have changed their monikers and the places where they grew up. Altered locales resemble original ones, with, for example, one mid-Atlantic city replacing another. Since divorce law varies by state, I do not change the states where interviewees terminated marriages or amounts of money demanded from those I call post-marital extortion victims. Ages and religions remain unchanged. The ages I mention are from the time of the interviews. Occupations have been altered. Changed professions are comparable to actual ones. Each narrative comes from a real interview with an actual person. There are no composite portraits. Questioning language and trying to change it is an attempt to revise assumptions and ideals. There is some terminology used in this book that challenges matrimony as a centering norm and the coupled nuclear family as superlatively timeless. I use these terms throughout, and the definitions are my own unless otherwise indicated. 1. Through the Looking Glass. Non-marital planning in a marriage-centric world. The most powerful ideas are those which are taken for granted. Doris Lessing, Under My Skin, Volume 1 of my autobiography, to 1949. Imagine being a professor who's just earned tenure. You work toward this goal for years, subsisting on abysmal wages while completing graduate coursework followed by doctoral examinations. Then came the real labor, researching and writing a 450-page dissertation. It was arduous, but 8 years of weekends camped at various New York City libraries paid off. A doctorate in English literature qualified you for the academic job market. A university in Connecticut made an offer. You accepted, relocated, and started up the next mountain, a 6-year climb toward tenure. This meant publishing, serving on university committees, and proving yourself in the classroom. Again, diligence paid off, and you achieved tenure and promotion to the rank of associate professor. This happened to me. The raise was modest, and the job remained demanding, but my satisfaction was palpable. Finally, I had a professional foothold and could stop thinking in 12-month increments, from contract renewal to contract renewal. When the congratulatory phone calls stopped, reality began sinking in. I realized it was time to consider the future in a new way, putting financial plans in place for myself and my loved ones. Toward this end, I assumed there were choices. I was correct. But I learned that in the United States, the central and sometimes sole way to protect oneself and one's family involves marriage. Looking down the road, I factored in Social Security. I anticipated one day receiving monies from a system into which I had long paid. Every paycheck I had ever earned withheld for Social Security. Hence, I should select a beneficiary. I decided on my sister. Incessant conversation, medical tests we'd seen each other through, and verbal pacts of commitment made her the right choice. Years of shared news, good, bad, irrelevant, had helped us both face the slings and arrows of outrageous fortune. An hour of research derailed my plan. I learned that as a never-married professional, I can't leave Social Security benefits to a loved one. The support Francis and I give each other goes unrecognized in a culture that distinguishes sharply between marriages and all other partnerships. Because our bond does not fit the connubial model, American law treats us as strangers to one another. It got worse. I discovered that my payments go back into the system. My situation is true of all never-married American wage earners. When they die, monies paid for their whole working lives are absorbed into Social Security's budget. So, whether they want to or not, all payers subsidize wedlock. If he married 3 times, a deceased worker's widow and both divorced spouses would get 100% of the sum he received while alive. None would have to demonstrate need or a history of financial dependence within the marriages. None would have had to pay anything toward Social Security. For a spouse, 1 year of matrimony is all it takes. 10 years are required of an ex-spouse. Francis and I had been together for over 10 years. No matter. But Social Security follows a non-marital relationships don't count rubric. This, combined with a matrimony is best for everyone always assumption, encourages Americans to wed, regardless of their beliefs. Since length of marriage determines one's ability to collect, the program goads each adult, happy or unhappy, to stay married. Of course, a crux federal program that rewards only one relationship implicitly diminishes other styles of pair bonding that increase, no pun intended, Social Security. Case in point, Francis and I remain a constant in each other's lives. If I predecease her, a safety net would increase her peace of mind. It might encourage her to take chances and expand her work as a property manager. Indeed, a non-marital Social Security option would foster small entrepreneurship by giving millions of Americans such protection. Social Security's lump sum death reimbursement could help her give me a proper funeral. All people in committed relationships deserve the opportunity to bury their loved ones respectfully. But Social Security reserves this benefit for spouses. This exclusion struck me as particularly disgraceful. We may not be married to each other, but neither Francis nor I would feel comfortable hurling the other's remains into a dumpster. Social Security is a third-party benefit. Such entitlements don't come from a person but another entity, such as the state or an employer. Since the federal government is Social Security's third party, I wondered how a national program could be so partial. If Social Security treated a particular ethnic or racial group preferentially, newspapers would publish exposés. Protesters would march. Lawsuits would proliferate. But marriage-centric policies evoke little, if any, outrage. A piece of related news caught my eye. Actress Melanie Griffith's divorce from actor Antonio Banderas after 18 years together. According to several magazines stacked in Central Connecticut University's Burritt Library reference area, Griffith and Banderas's union ended with a court mandate that he pay $65,000 per month in alimony. What could explain this jaw-dropping amount? As I heard it explained, alimony is compensatory. Spouses, so the rationale goes, deserve recompense for years when they put careers on hold to do matrimonial things. Griffith worked throughout her marriage to Banderas, appearing in films like Adrian Lyne's 1997 Lolita, Larry Clark's 1998 Another Day in Paradise, Woody Allen's Celebrity, made that same year, and Rob Minkoff's 2002 Stuart Little 2. The scion of actors, Griffith grew up in Acton, California, on a 200-acre ranch. After enjoying a lifestyle undreamt of by most Americans, she launched her career in the late 1960s. Ironically, it peaked with Mike Nichols's 1988 film Working Girl, the story of scrappy secretary Tess McGill, a Wall Street outsider who breaks into investment banking. Griffith, by contrast, is a Hollywood insider with an acting income buttressed by valuable assets. She split with Banderas proceeds from their Hancock Park, California estate, $15.9 million, and retained sole ownership of an Aspen, Colorado home. Her art collection includes an original Pablo Picasso work, The Painter and His Model. Clearly, no one needs to organize a bake sale for her. Heading home, I thought of various gay celebrities fetting themselves with weddings, musician Elton John and filmmaker David Furnish, who married at Guildhall, Windsor, England in 2005, comedienne Ellen and actress Portia DeGeneres, who took 2008 vows in Los Angeles. I imagined these new matrimonial standard-bearers years down the road, scanning divorce papers as they stammered, "But no one told us about this part." Judith Plasko, professor emeritus of religious studies at Manhattan College, might have warned them. In 2004, she and Smith College government professor Martha Acklesberg issued a public statement that they would not wed. Were we to marry, we would be contributing to the perpetuation of a norm of coupledness. At this moment, when there is so much focus on celebrating the right to marry, we want to hold up a vision of a society in which basic rights are not tied to marriage, and in which there are many ways to organize one's intimate life. I had thanked Plaskow via email for taking such a morally coherent stance. Questioning wedlock, straight or gay, takes courage in a nation largely devoted to the marriage principle. Her reply caught me off guard. While their views hadn't changed, she and Acklesberg were considering matrimony. "Unfortunately, there's only one way around the estate tax," she wrote ruefully. Estate tax? Recalling Plasko's note, I decided to investigate. My accountant, Mario, shared more disturbing information. Wedlock, he explained, is American inheritance's litmus test. In cases of intestacy, a spouse automatically receives all assets. Relationship length is irrelevant. At that point, I had been with my boyfriend for 4 years. A man who married someone he barely knew in Las Vegas would have enjoyed stronger protections than Jim did if I had no will. This remains true. In most states, Georgia is an exception, disinheriting spouses who have not waived their rights with prenuptial agreements is illegal. Community property states consider everything accumulated during a marriage as belonging to both parties. These laws aim to keep married people's focus exclusive. They can prevent a divorcing Californian from gifting cherished possessions to loved ones. Connecticut exempts husbands and wives from tariffs otherwise due when assets transfer from one person to another. Bequeathing one's residence to an unmarried partner is a taxable event, so selling can be the only option for those in high-income brackets. In estate tax, the first $2 million are tax-free, Mario explained. After that, it changes. The next $1.6 million garners a 7.2% tax. That's just over $115,000. It goes up from there. Hanging up the phone, I scrutinized my 1,600-square-foot house, which had been advertised with the phrase, "needs TLC." After spending years in tiny apartments, refurbishing this colonial had been a wonderful adventure. Jim insulated the attic, upgraded a flagging electrical system, and set up our internet. Beneficiary of the house, he lives with me part-time, a setup common among academics who require ample privacy to read and write. I knew that the place would never appreciate to anything near $2 million. So my untimely demise would not produce a bill so steep that after losing me, Jim would also part with our home. But pricey estates are common in Connecticut. Many properties are worth at least $2 million. If their occupants cannot write a $115,000 check, they will lose their homes when a co-owner dies. It can take less than a death for the state's approximately 5,500 farmers. Farming has become a growth field in Connecticut, especially among young people aware of the premium on organic food and eager to own land despite high real estate prices. They qualify for family farm loans if applicants are linked by blood or marriage. Non-marital farmers working cooperatively, who need money to sustain operations or handle emergencies, don't meet governmental criteria. They can lose property because of bad weather, broken equipment, or any shock that soil is heir to. Again, the law capriciously protects certain people. What does marriage have to do with farming? And encourages everyone to follow a single model. Curiouser and curiouser. Lewis Carroll's Alice says after tasting cake that elongates her neck. Like the naïf from Alice's Adventures in Wonderland, I felt as though I'd gone down a rabbit hole into someplace bizarre, yet familiar. Like the world of Through the Looking Glass and what Alice found there, this realm was laid out as a chessboard, but promotion rested on betrothal rather than movement to the 8th row. A morning of Googling revealed data on nearby states. Massachusetts has a lower tax threshold than Connecticut, $1 million. Danvers-based attorney David E. Peterson recommended splitting estates with assets of $1.5 million and opening 2 revocable trusts to keep each potential survivor under the $1 million mark. This would prevent a $64,000 penalty. Voila! No estate tax. No estate tax for married people, that is. I had known that America incentivizes marriage. Just how powerfully it does so was coming into focus. This issue had not spurred my Planning for the Future initiative. I set out to overcome a long-standing fear of money. Like many academics, I spent years without enough for essentials. This leaves vestigial anxiety. The mere prospect of getting organized and setting financial goals generates queasiness. In my effort to stop functioning like a nervous graduate student, I was discovering just how powerful the American marriage system was. An investment advisor from my bank suggested opening a traditional IRA as an income shelter, explaining that I would get a deduction on my contributions, and taxes on the account's income would be deferred. I asked about opening an IRA for myself and one for Jim, and learned that I couldn't. In spousal IRAs, one partner contributes to a tax-deferred retirement account. But, as its name suggests, this option is tailored to marrieds. Surely there were exceptions, I prodded. What if an unwed person is sick, unemployed, taking time from work to care for a dependent child or senior? No. Spousal IRAs made no exceptions. I could name Jim as a beneficiary, but even here, marital exceptionalism prevailed. Spouses who tap into an IRA early don't pay the 10% tax imposed on unwed people, if the expenses exceed the account holder's adjusted gross income by 7.5%. Even a financially unsophisticated academic could grasp the ramifications. While it's generally unwise to draw on an IRA prematurely, never married Americans who have no choice lose 10% of their withdrawals. I had entered the orbit of professionals paid to evaluate life's practical angles. They tend to operate in the here and now, withholding judgment and navigating a realm that simply does its business. Part of that business is legally gaming the tax system. Toward this end, financial advisors dispense advice that normalizes marital privilege. Matrimonial superiority is treated as an incontrovertible fact. Clients get the message. The message is passed on. Way leads on to way, Robert Frost wrote in his lyric, The Road Not Taken. I could see how one marriage-based benefit led to the next, and to the subsidy after that. All flowed from the belief that once married, spouses lose their separate identities. Each newlywed couple becomes a monad. Accordingly, what belongs to one belongs to the other. A husband's health insurance must include his wife. Her employment at a college extends to her husband. I'd knocked around universities long enough to observe the practice of spousal hiring, which gives married job candidates preferential treatment. Spouses are routinely interviewed for pre-existing positions, and job lines opened for people married to important scholars. In 1977, Harvard offered the Titanic cognitive scientist Amos Tversky a tenured professorship. His biographer explains that it took them a few weeks to throw in an assistant professorship for Barbara Tversky. The phrase, to throw in, makes one of the world's most coveted academic jobs sound like a complimentary dessert given by a restaurant manager. In 1978, the Tverskys landed at Stanford University, whose psychology department accommodated them both. In 2014, Dartmouth appointed Carolyn Dever to a dual position, professor of English and university provost. Dever will be joined in Hanover by her husband, Paul Young, who will be a professor of film and media studies at Dartmouth, the press release reads. The late Tversky built a career debunking assumptions, showing how people oblivious to their biases follow instinct with unwarranted optimism. Carolyn Dever studies Victorian fiction, focusing on representations of motherhood. Such policers of ideology become oddly complacent when receiving matrimonial benefits. I had yet to hear a professor whose wife found work at his home institution ask why their marriage positively influenced hiring, when a candidate's maleness or heterosexuality could not. I'd never heard a married academic question her husband's free access to university gyms, while non-marital partners paid fees. College orientations make strenuous efforts at sensitivity. I am regularly invited to events that encourage academics to unearth buried prejudice. Facilitators deploy now familiar terms, otherness, shaming, and what English professor Robert Boyers considers an overused noun, privilege. Boyers notes that while no one could deny various forms of social advantage, to occasionally berate oneself for being privileged while making demonstrations of camaraderie with less privileged groups requires minimal emotional engagement. In my experience, academic professional development has expanded to include the words diversity, equity, and inclusiveness. Yet it does not include diverse beliefs about family, relationship equity, or the inclusion of non-marital people in benefit-conferring programs. Marriage as a privileging category and relationship status discrimination are largely ignored. One must wonder why seminars designed to highlight power imbalances don't question an institution that unequally distributes hundreds of benefits. Perhaps the subject of relationship status discrimination would disrupt proceedings by pushing academics to discuss how they live and which privileges they embrace, replacing perfunctory self-flagellation with dialogue. A gift from our dean, Micah Ingrid Phillipson's book, Challenges of the Faculty Career for Women, Success and Sacrifice, had sat on my shelf for 2 years. I opened it, hoping to find something on women's concerns about marriage-centric hiring. Instead, I found a plea to give marrieds special treatment, discussing an actual school assigned the pseudonym Flagship University. Phillipson describes a real couple. Flagship hired the wife for a permanent teaching job and generously gave the husband a postdoctoral fellowship. According to a married colleague, with whom the married author concurs, this was injurious. Candidates married to people tracked for tenure should be foisted on departments. In Dr. Ingerson Knowles' opinion, the university should offer the spouse a teaching appointment. His research may not be completely what the department wants to do, but it is more important to keep people happy than to try to be very precise about what kind of science you want to have. More important for a university to keep people happy than set research standards? I reread the sentence twice before grasping its claim. In academia, cheerfulness should trump intellectual rigor, but only where spouses are concerned. Phillipson advocates bending rules for married faculty, not unwed or never married professors. She ignores academics who wish to put forth friends, lovers, or other long-term partners for consideration in package hiring deals. One must conclude that, in her view, married scholars' feelings matter, and non-marital professors' emotions don't. Unfortunately, Phillipson's blind spot is common. Universities' overall message to students is repudiate bigotry and denounce nepotism, except for bigotry against the unwed and matrimonial nepotism. They're okay. Graduate and undergraduate students witness yet another example of special efforts on behalf of the married household, made by those content to let other families fend for themselves. These reinforce larger cultural messages about marital exceptionalism. Like Frost's Narrator, I found myself wandering extemporaneously. Having entered marital privilege's deep undergrowth, I was stumbling on inequity after inequity, accumulating information faster than I could absorb its outrageousness. Researching real estate taxes in New York, where I grew up, I learned that the first $2,062,500 of an estate are non-taxable. After that, unwed residents pay. New York City swells with denizens who arrange their lives non-maritally. In 2012, the New York Times featured 3 men and 2 women who shared an apartment in the slowly gentrifying section of Bushwick, Brooklyn. This was no hodgepodge of tenants splitting bills until they found spouses. It was a friendship-based household consisting of 2 architectural designers, 2 fashion designers, and 1 advertising executive, all in their 20s, who spruced up a 2,700-square-foot loft and agreed to live together for 10 years. Marriage fundamentalists denounce such setups as newfangled. Actually, friend-centered homes have a long history and support from thinkers like Aristotle, 384 to 322 BCE, one of Western philosophy's 2 most influential figures. Those who welcome each other but do not live together would seem to have goodwill rather than friendship. For nothing is as proper to friends as living together. My homeowner's real estate appetite whetted, I checked announcements of Bushwick open houses. A 4-story townhouse on Bleecker Street, in the heart of trendy and upcoming Bushwick, had an asking price of $1,300,000. A similar Wilson Avenue property was listed at $2 million, and a 4-story Green Street townhome at $3 million. Given the pace at which New York City real estate appreciates, A $2,062,500 exemption did not seem monumental. The discrepancy in treatment between married and unmarried New Yorkers looked punitive. Throughout neighborhoods like Bushwick,
Sample complete. Ready to continue?